Hello, welcome to Legislative Report. I'm State Representative Kate Harper, the 61st District in Montgomery County. One of the most important responsibilities of our Commonwealth is taking care of children who have been abused, neglected, or abandoned by their parents. These children want and deserve the same thing any child needs, to grow up in a safe, nurturing, and permanent family. As chairman of Children and Youth Committee, I hosted a hearing earlier this year on one initiative that is aimed toward achieving that goal for some of our most vulnerable children. It's called Family Group Decision Making, and during the next half hour, you'll learn about that process from Supreme Court Justice Max Baer. We're going to get started with our hearing on family group decision making and court improvements in the area of children and youth. And we'll see how far we can get before we have to break and go to the floor. And I apologize again for that, but I'm glad that Justice is here, and I'm sure that we can learn a lot in the short time that we have available to us. So you have the floor.
Thank you. I'm Max Baer. I am Justice on the Pennsylvania Supreme Court, and when I am not engaged in that full-time activity, I am engaged in reforming child welfare in Pennsylvania. And just so that everybody's clear, child welfare is dependency or abused and neglected kids, distinguished from custody, which we desperately need to take on, but not today, and probably not this year. Delinquency, juvenile justice, which again is always need a reform, but with JCJC does well in Pennsylvania, and we keep an eye on. So what we're doing and what brings us and me here today is child welfare or abused and neglected kids. To my left, your right, is Sandy Moore. And Sandy will feel free to interrupt me, and I like it when she does. And you all should feel free to interrupt me. It's a pleasure to be on this side of the bench instead of that side, and I like engaging in oral argument, which I don't get to do much. So please do feel free to interrupt at any time, ask anything. If I can answer questions that you have, then my time here is very worthwhile. Let me start really quickly as to not so much the history of Pennsylvania, which we can do, and how it is that Sandy's here, the courts have an office, and thousands of people all over Pennsylvania, judges, social workers, children welfare professionals are engaged in this systemic reform. But go back before that, because I think this is an extraordinarily important hearing. I think Pennsylvania, because of you, Representative Harper, in this committee, has a chance to jump in front of the world. And frankly, that's unusual. We're not in front of the world much in these kinds of endeavors. And so, briefly, about 900 years ago, we started developing the common law dispute resolution system, which we all know from no other reason TV, with opening, closing statements, rules of procedure, rules of evidence, examination, cross-examination, burdens of proof, etc. Well, that's the only dispute resolution system we really know in the United States. And so when new problems arise in the legal field, that system is automatically employed to be the dispute resolution system. We could get into, on a different hearing at a different date, how well that works for civil, how well that works for criminal, and the like. There was really, until 1960 or so, almost no real dependency court. There was no record made of proceedings. There was no rules of evidence in Pennsylvania until about 3 years ago. Rules of evidence didn't apply. The judge took the child and the parents into chambers and said, now what in the world's going on here, and let's straighten this out. Then, of course, the Civil Rights Revolution occurred, and the United States Supreme Court began to apply some constitutional rights in juvenile law, and that especially was true in the delinquency side, which can involve the deprivation of liberty. It crept over to some extent onto the dependency side. But still, the court worked around, and it was pretty informal. And that worked. Between 1990 and 1994, 95, dependency exploded. And again, it's not an appropriate subject of this hearing as to why, but it goes to the creation of crack cocaine, terribly plentiful, terribly addictive, terribly cheap, goes to the legitimacy of illegitimate kids, to coin a phrase, that we went from it being a stigma to have a child out of wedlock to it being socially acceptable, and young women in need of companionship and love, having children for that purpose, etc. So by 94, dependency had exploded, and it was no longer bring Johnny into the chambers and let's talk about him. So faced with this onslaught, about 560,000 kids in foster care in Pennsylvania, the federal government, in the United States, the federal government got involved because it was costing too much money. And that's why. And they changed federal policy. And they changed federal policy from we can return every child, and so let's keep the children in foster care, temporary care until we get them returned, to children are entitled to permanency, which is what you know today. And if a parent cannot correct the problem that caused the child to go into care, then we have to look for alternative permanency. Well, that ramped up the contentiousness of dependency hearings. And again, we looked to the traditional dispute resolution system because it's all we knew. Now, the truth is it doesn't work. It doesn't work. And think about it. Well, if you have a criminal trial, civil trial, it doesn't matter. You got let's talk criminal just because it's the easiest. You got a DA. What does the DA want? Respectfully, my son's an assistant DA in Philadelphia County. The DA wants the conviction. Now, they play by rules, but they want the conviction. What's the defense want? They want an acquittal. Does the defense care if their person did it or not? Of course not. Our system's not even designed that way. And so the system works. Now let's flip to dependency for 1 second. What does the county want, the government? They want what's best for the child. And generally that they would acknowledge that's to go home if possible. What does the parent advocate want? They want what's best for the child, and they generally want the child to go home. What's the child advocate want? What's best for the child? Nobody's fighting. The system that, what's the CASA, the guardian ad litem, everybody's trying to figure out what's best for the child. Well, the system that works pretty well to have a jury determine guilt and innocence doesn't work at all well when everybody is trying to get to the same result and yet doesn't have a system that really allows you to delve into what that result should be. Now, juvenile court has sort of recognized this without thinking about it. And if you go to a juvenile court proceeding, it's a very, very informal proceeding. You generally do not have opening statements. You do not have closing statements. The rules of evidence are relaxed. You zip around. The judge sits in the front of the room. And I did this for about 6 years. I've been involved in it for about 20 years. And the judge zips around the room, and what are you saying? What are you saying? What are you saying? What do you say? And what do you say to that? And so the system already is not quite what it is, but it's still a court proceeding. Well, the academics and the social thinkers looked at this and said, this is crazy. The state's not a good parent, and we know that. Juvenile court is not well suited to understand in the 10 minutes of quality time that you used to get every 6 months under our statute and in our real world, is not well suited to really understand the strengths and weaknesses of this family, of this child, how this key unlocks this door, how we get this child to successful adulthood. And so different models began to emerge. The model of family group decision-making works. It is from New Zealand. It is enshrined in the New Zealand Constitution, although I will tell you, don't look at their Constitution like ours. It's fascinating. It's sort of a ramshackle hodgepodge of an oral constitution, which, of course, Great Britain has, a written constitution, and statutes that are deemed constitutional. This comes from, and I shared it with your researcher, the Children, Young Persons, and Their Family Acts of 1989. And I would commend that to you as a pretty decent guide for a practice that works. What makes New Zealand unique is that their statutory law, which of course is what you're engaged in drafting, their statutory law provides that no child shall be found dependent until they've had a family group decision-making conference. And therefore, it's mandated. And that's important. Now, there are exceptions in the rule. You know, one exception could be until they're offered, because if they turn it down, it's probably not going to be successful. Another exception is domestic violence. Another exception can be insanity, youth of the child, etc. But the rule is you get the family group decision-making conference. Now, the key to that, and I'm going to give this to Sandy for a second, and we can talk about other things, but the key to that, and my most important respectful message to you, is family time. That means the professionals get out of the room and the family talk about their child. Now, family is an extended term. Family can be a member of the church community, a member of the beloved football coach, or the beloved next-door neighbor. Family is the proverbial village that it can take to raise a child. So who goes into the room for family group decision-making is those individuals who know this child intimately, who love this child. And again, I say this all the time. I love my guys. They're 31 and 27, and if the phone rings, I'm leaving this hearing to take care of them. I care deeply about these kids, but I don't love them like I love my kids. But their parents do. Their aunts, their uncles do. Their grandparents do. Those people who have watched them from the day they were born do. And those are the people that understand the strengths and weaknesses of this child, what drives this child. They understand the strengths and weaknesses of this family and how this family can be the key to bringing this child up successfully. And by throwing the professionals out of the room, and when I say throwing, I'm talking about the process, the statute, and providing this family with the opportunity to talk among itself about the child's difficulties that bring them there today, and who among them can step up for the child and who can do what so that they can raise the child. And have them come to the solution is infinitely more effective, has far better likelihood of success than a procedure where the judge in the 10 minutes of quality time says, do this, 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 and this next case. And it's not that the judge, myself included, doesn't sweat bullets over this. It's that the judge doesn't know the child, the judge doesn't know the family, the judge doesn't have the key to unlock what works. So family time is key to empower the family to figure out how to save this child. Where the social work comes in is before, because you have to have the right people in the room or you have nothing, and afterward, because respectfully, again, I'd be naive if I thought that you could do this and send them on their way and it would work. The social work comes in to prop the family up as the plan begins to be implemented in infinite ways. One of the ways you hear all the time is to the extent that the parent, and generally it's mom, we love it if it's dad. In fact, we're doing important work in getting dads and dads' families involved. Paternal grandparents are a wonderful source of stepping up for kids, and they're never asked. But generally it's mom. To the extent she's out of control, she's on crack cocaine, she's young, she's wild. One of the things that law enforcement can do and social workers can do is keep her out of the way, because otherwise she's going to disrupt the family trying to step up for the child. And one of the things I used to hear when we were in the rudimentary beginnings of this and I was on the bench is, you know, to say to uncle, will you take the child? I'm not taking this child because my sister calls the police on me. My family's getting disrupted. She's filing children and youth and reporting me for child abuse, and they're out here investigating me. So that's one of the places where the state can step up. And just an example. But the point being that we need to get the right people in the room to do a family group. We need to provide them private time so that this plan is theirs and they take ownership of it. And then we need, through intense social work at the beginning and skillful social work and law enforcement and courts, to have the family assist the family in the implementation and success. And, you know, and this is like your families. The best made plan may not work. Do you throw it out? No. You go back to the kitchen table and you work it out again and again and again. And that's where we can help. One more comment, and I'll yield to Sandy. two more comments, I think. There is a process called family finding. I believe that's in front of your committee. Family finding is without being long-winded about it, it's a process that a gentleman named Kevin Campbell, who's been in Pennsylvania 25 times under contracts that we've signed with him, and has taught our people. And it's used to find family and significant others when the social workers tell you they don't exist. It is always successful. Kevin can find 40 relatives for any child in 15 minutes. And I've seen him do it. We've all seen him do it. It is unbelievable. Now, Kevin would have been a fabulous lawyer. When he starts asking questions to the people who knew the kids to gather the information he needs to do his search, he's cross-examining like Perry Mason. And so you need to do very good social work to get your information. Then you plug it in, and then you get the people. And if you don't have the right people in the room, and enough of them who are competent and able to parent, and raise a child, then you're not successful. So family finding is an adjunct to this. It was not created for this purpose. We adapted it. Kevin loves our adaptation. He now teaches it all over the country. It was really adapted to take care of kids aging out while in foster care, so that they didn't age out and fail. They had somebody to go to when the system threw them out, which happens in many states. Does not happen as much in Pennsylvania. We do a much better job. And I wanted to make that comment because, again, you need the right people in the room. And the other thing I was going to say to you very, very respectfully, and I appreciate you all being here, and again, we'll move on, is I understand the realities of the political process. We in Pennsylvania, the judiciary working in child welfare, many of the human services director working in child welfare are doing this and are pushing this. Now, two comments. The first is that we don't want the rule of unintended consequences to occur because of politics. If the best you could pass politically would be some aspect that does not include private time for the families, I would respectfully ask you to do nothing. Because if you pass a statute that does not have family time, then that will provide cover, a statutory mandate or discretion for those who don't want to provide family time because it takes the power away from the professionals. And we can mandate that as a judicial branch directing in our courtrooms, so long as you don't mandate something else. So we love
Justice Baird, just so we can clarify it and move it just a little bit. You're advocating that we do family group decision making with a trained facilitator, aren't you?
Absolutely.
Or are you just not just a family in a room by themselves, because they wouldn't be in dependency or delinquency court if they had their act together?
Absolutely.
However, the facilitator does not go with the family during the private family time. The facilitator and all professional people remain outside of the room. And you're going to hear later, I think at another hearing, about what the model family group is. We're not going through that. There is a check and balance always in family group. When the family creates their plan, they present that plan to all of the professionals. The professionals have to agree with the family that the plan covers and takes care of the safety issues that were concerning to the agency and to the court. So it's not just a family going into a room by themselves and creating a plan. There is a check and balance. But the facilitator helps in the initial process of steps of the meeting and in the end steps of the meeting. But the private family time, we're advocating be private family time. The family decides who goes into that room with them, because the conversations when families are in there by themselves look very different than when facilitators are in the room.
And again, Representative Harper, to be clear, and thank you, Sandy, I agree. The social workers do a great deal of planning, or the family group decision making will not succeed. As
a legislator, though, I'm trying to figure out what it is that you're hoping the committee would work on.
We would like the committee to thank you for that question. Let me expand a little bit. With the exception of New Zealand, most entities that do family group decision-making have it as a small appendage to the traditional dispute resolution system. In Pennsylvania, we have it in probably 50 of our 67 counties, but a very small percentage of cases actually get the opportunity. The reason is that there's a fair amount of front-loading of time to do family finding, to prepare for the conference, to go in and facilitate the conference. Now, in terms of totality of time spent on a dependency case, it's arguable and it's intuitive that you spend less time because the case will not still be being reviewed 2 years, 3 years down the road. It will be closed relatively quickly, but there's still time, upfront time, which makes people resistant. We'd like family group decision-making, as it is in New Zealand, to be the model for any family that wants it as a first alternative before you go into court.
Okay,
So
that's a very clear explanation, and I think the committee appreciates that.
So you're offered family group. If you avail it, you get it done right. A small but so important part of it that distinguishes it from a court conciliation, an informal meeting where the professionals are sitting around and maybe the family is or is not, is when, after facilitating with expertise, the facilitator says, now it's time for me and the other people to leave the room, and it's time for you to work out what to do with your child. And then they come back in. And if they think that that's a foolish plan or a plan doomed to failure, they say so. At the end of all of this, it's taken before the court because there is still constitutional due process concerns. And the court says, yes, this will work, or no, you better go back and do this again. And so the court is still as a backdrop. The professionals are still there. The reason I talk about the family time so much is that there are lots of other models out there that are nothing more than fancy court conciliations because there's no family time.
Now, because of our expedited schedule, I'm going to ask Sandy if she has something she wants to add, and then we'll take questions briefly from the members. Sandy?
You know, I think Justice has explained it well enough at this point, and certainly we're welcome to come back. I'm welcome to come back anytime the committee would like. So I think I'd rather just give my time to questions.
All right, great. Then I'll start off. We're having a legislation pending in front of us because of the concern of what happened in Lucerne County.
Sure.
And it would actually make the process perhaps more adversarial to require that every child be considered informa pauperis and get a free lawyer before they are, adjudicated by the court. How would that play into this? It seems it would be at variance with this approach that you're suggesting.
No, it really would not. And I'm not sure how consequential that is in any event. If and when this would occur, this would be offered to a family before they go to court. If they work this out, then the court hearing is merely to approve the consent decree, to put this in different terms that I trust you to understand. If that does not get worked out and you go to a hearing under the Juvenile Act, an abused and neglected child is already entitled to a hearing, and they're all deemed to be informa pauperis because they're children. Right. In juvenile justice, which is distinguishable and, of course, is what was involved in Luzerne County, and we can talk about that if you want. And that's where I think the legislation you're referring to is pertinent. And the question is, should the public defender just represent everybody or regardless of need or not? And again, if you want me to talk about that, I'll be glad to.
No, your point is it's not at variance with the family group decision-making model.
And it is not, absolutely not. And it's frankly not in variance with the Pennsylvania Juvenile Act as it currently exists. Okay,
great. Representative Will Tolman from Adams and York County has a question. Go ahead, Will.
Thank you, Madam Chair. Just real quick, and I'm going to reference to a case in York County, and Secretary McElrath is back there. She used to do York County. But anyways, the family group decision-making and the case that I'm going to refer to, that is not going to be unanimous. It's going to be split, probably along paternal-maternal lines. So how does the court then resolve that? Thank you.
Well,
I think the process of family group decision making is really to bring the family together to come up with what should be the recommendation to the court. Ultimately, if it comes to the court and the family can't resolve it, and I think this is true in New Zealand too, the judge has to ultimately make a decision. But the pushback from the court and the push from the agency is, family, do you want to be in charge of caring for your children, or do you want a stranger? And quite honestly, the judge is still a stranger making decisions about your family. So, the hope is that the family can resolve it. If not, ultimately, the court's got to make a decision regarding safety of children. It doesn't dismiss that responsibility of the court.
And Representative Tallman, I would just say that's not a bad scenario, because what you're telling me is we have adults who love this child enough to fight about him, which is custody. At least we got people that love this child and want to raise this child. And now we got to work out how to make sure the child is not the victim of the animosity between them. Typically, in dependency, our problem is that we don't have people that want to raise this child. And that's what we're trying to find.
Thank you very much. Unfortunately, that's all the time we have for questions. Justice Behr, I really appreciate your coming. Ms. Moore, I noticed Deputy Secretary McElrath is here. We're going to have another hearing on this. The session schedule has interfered with our ability to hear you out on this. I do want to tell the committee members that you do have in your packets the written materials relating to this topic, and we will have to take it up again.
May I have 30 seconds to make a wholly different point?
Rebuttal or closing argument?
Neither. Missed argument that I know is important to you.
Sure, go right ahead,
Justice. This practice
Justice.
saves a fortune. It costs $50,000 a year to keep a child in foster care. It costs far less to send them home. The social work is much cheaper than the placement. We've taken 7,700 kids out of care in Pennsylvania using this process. That's a gross savings of $350 million, and we have figured out it's a net savings to Pennsylvania of $117 million. How often can you do something that's good for kids and saves you money? Thank you, Madam Chair.
All right. Well, I should give you the last word, Justice, but Representative Mao is on my committee also wants 30 seconds. So
30 seconds, I promise. I just want to say thank you. Thank you to all of you. We've been working in this area along with Deputy Secretary McElrath, and Sandy has sat in with us and given us guidance, and I am so enthused that you're here, and I'm appreciative of your leadership in this, and we're going to make sure that this legislation comes to fruition. Thank you.
There's nothing more important to Pennsylvania kids. If you need me, I'll come back.
Well, you've been watching a hearing of the House Children and Youth Committee on the topic of family group decision making. I'm State Representative Kate Harper, chair of the committee. If you have any questions about what you've seen, feel free to contact me at my local office or through my website. That information will be shown on your screen in just a moment. Thanks for watching. Please join me again for Legislative Report.